Hello, I'm Dan Marr from Hamblett and Kerrigan. I've been practicing here in the Nashua law firm of Hamblett and Kerrigan for approximately 35 years. Before that, I was a clerk for the courts. So I've been licensed to practice law in New Hampshire for 36 years. About 28 years I've been licensed also in Massachusetts. So I practice actively in both states. I'm going to be talking today about employment non-competes, an update of this. This is now May 2nd, 2024, and there's been a variety of things that have been going on in regards to non-competes. I'm going to discuss them versus confidentiality and non-solicitation agreements in an employment context. There are, in New Hampshire, we've had before a statute that has some strict guidelines as to when you can have non-competes. There's some income restrictions. There's also an obligation to provide a non-compete before somebody accepts their job. And in Massachusetts, there's also some restrictions on those. And non-competes are distinguished between, an employment non-compete is one that says after you leave our employment and while you're employed with us, of course, but after you leave us is a real important part. You can't work for another competitor in this geographical area or this time frame. Now, there's been discussions about that over the years, and some of the courts have narrowly construed them. Some courts, like in California, have actually removed them. But now, the Federal Trade Commission has announced that it's going to be subject to some final rules in coming forward. But they've banned non-competes, employment non-competes. They found that they interrupt the flow of people's ability to compete, and it's an antitrust thought process there. And in that situation, really what it is sometimes non-competes have been used in the past to get control over the employees. The employee doesn't have anywhere else to go, because if they have to be, they can't work in this industry for a 50-mile radius or maybe a 20-mile radius even. They'd have to move their house. It would be too burdensome for them to actually go and compete and work in that industry somewhere else. So that and some other reasons, the non-competes have been disfavored over laws and over the years, and now the federal government has come forward and actually made a rule. There's going to be probably some litigation in regards to this. My guess is there's going to be some fights challenging whether or not the FTC has the authority to do this. But assuming that it does go forward and it's effective, it's going to ban non-competes. Employment non-solicitations are a different issue. That's something particularly like within sales or other people that have customer contacts that say you can't work with this customer that you've had contact with. We put Dan Marr in front of this client. Lawyers, there's not a non-compete allowed anyway. But if I'm working for a company, Acme sales company, and Dan Marr is now working with Bob's Pizza, and I have a relationship with Bob's Pizza, and then I leave and I go to not to Smith Company instead of Acme. I leave over and go to Smith, and I want to go and hit Bob's Pizza. Acme has a legitimate right to say, wait a minute, Dan, give us an opportunity to put a new face in front of them. We paid for you to have that relationship with Bob, and you developed it while as an employee for us. That's our customer. Let us have an opportunity to get that customer and retain that customer. And that's something that's generally considered fair in a non-solicitation agreement. That's different than a non-compete agreement. There's also provisions in agreements that say confidentiality, don't take our trade secrets. If you know our profit margins, you can't share them with somebody else at a competitor. All of those are not touched by the FTC rule, or most, I don't know of any states that go and say you can't enforce the true confidentiality agreements. So those are going to be in place. So you can create, as an employer, non-solicitation confidentiality agreements, invention agreements saying that if you invented something while you're working for us, these are ours. No moonlighting while you're working for us. If you're getting paid for full efforts with our company, then you can't work for somebody else. Those types of things generally can be enforced, but non-competition agreements are going to be, in the upcoming months, there's going to be a lot of dealing with this, but the FTC right now has said we're going to be passing a law that's going to ban it across the entire nation. So if you have questions in regards to this or other questions, you can check out our vlogs that I've done and others have done in this firm, or blogs, and my radio show that was through the beginning of last year. I did it for several years. All of that's on our website at nashualaw.com. That's all one word, nashualaw.com. Or you can call me at 603-883-5501. That's 603-883-5501. Look forward to the opportunity of working with you if the opportunity so arises. Thank you.